All right, check. Hey, well, about a 15-minute delay. Sorry, guys. Just reset the audio. So the video is really slow right now, but thanks for bearing with, and hopefully we can make our way through this together. So without further ado, I'll jump into our avo.com questions to make sure we get to those. And if you are still live, anybody's still on, I do apologize for that long delay. That was just due to some sort of an audio issue and a video connection. So we're back at it, and we'll hopefully get this show back on the road next week in working order. So all right, so I'll open up this page. I think I did see a few questions come in over the week from Avo, and we'll jump to those patents and trademark questions coming up here next. All right, yeah, it's like 2 patent infringement questions. And I'll share my screen here so you guys can see that. All right, so the first one here is coming out of Los Angeles, California. And we got, I was wondering if this product is patented, is the question. And I found a product on Amazon where its invention is patented, but it says it is expired. However, this company has this product commercialized, but it can't find its patent on Google or elsewhere. Would I be in the clear to commercialize something similar? All right, so they want to see if this patent is expired. Well, one easy way is to go look up the patent itself. And it looks like if this is the actual number, yeah, patent 1327437, that would be a really old patent. I think it'd be worthwhile to investigate to see if that's really the right number. One way to check and see, and of course, you know, my computer's locking up here. There we go. You go to Google Patents. Yeah, just apologize for the technical difficulties today. Sorry about that. Well, while that's coming up, we'll just we'll stop sharing, see if things will load a little bit faster. Justin, thanks for hanging in. I appreciate it. And anybody else that's in there hanging in live, we just had some issues with audio and video earlier. And now we have some internet issues. So we're just kind of battling all the gremlins today, guys. So thank you for your patience. All right. Well, if you have any questions out there live, we can take those. Right now we're having trouble getting the URL to load up. Yeah, it's good to have you, Justin. Yeah, thanks, man. I appreciate it. So yeah, back to that question. For some reason, Google Patents isn't loading. So we'll get that up and run as soon as we can. Let's take a look at this link here. This condiment fork, it's called the fridge fork. And again, just having trouble getting the websites to load up right now. But for the most part, if an invention's expired, okay, if it's gone, abandoned, or if the actual term, right, a utility patent is good for 20 years from the date of filing. So if it's been that long, right, since they've actually, you know, filed and protected their invention, that is the beauty of patent law, right? That is why patents exist, is so that we reward the inventor for a small amount of time, and then after that period, it goes to the public. Right? That is the beauty of patenting. And so you bet, if it's expired, and I wish I could confirm that for you, but assuming it is expired, then you can commercialize, make something exactly the same, put your own brand on it, and commercialize it, or put it to use in your own purposes for your company to make it better. So that is patent law. And for this particular fork, looks like there's a condiment fork that they're interested in. Yes, just as long as you can confirm that it is indeed expired, that'll work. It's always worth considering, before you launch into business and perhaps take on investor money and spend a good amount of capital and time, to do what's called a freedom to operate opinion. And we get asked this quite a bit from business owners, not looking to get a patent, but just saying, hey, look, what's my risk of being sued out there if I go, dip my toe in the water and start selling? This is a great question to ask and something we can help with, right? We do a survey of all patents that are in that area of what's being sold, right? What you plan to sell, whether that's goods or services, to see if there's any risk of, patent trolls that might be out there lurking, right? Waiting to just slap you with a cease and desist litigation, or other competitors you might not know about that have patents, so that you know ahead of time before you go, start selling and infringing unknowingly. So check on that first. Thanks for that question out of LA. Let's jump back to our second question here and see if we have any live questions. Nothing live yet. So the second question comes out of San Francisco, California area. Divided patent infringement for a method claim. So they have a method claim. The steps needed to be carried out by two parties. And as you go into detail here, the claim is being infringed by Company A and Company B. Company A is responsible for all the infringement. Company B is not really aware of it, but Company A is. They go on to say the company is doing to hundreds of other companies. Let's say they sue Company A and B, and the court decides that both parties are infringers. Can I claim damages from Company A for all damages or only damages related to Company B? So this is interesting. What I'll do is I'll put this question in the comments just so you guys can see that. I know it's sometimes hard to do screen sharing. So there's the question. On some of these platforms, Twitch and Google, they're hard to see. But when you have two parties and they're both potentially infringing, the question is the first, right, the party upstream, are they inducing, right, induced infringement? Are they inducing a subsequent downstream supplier, retailer, salesperson, or company to infringe unknowingly? So making products perhaps overseas is kind of the classic example. And saying, hey, would you be our retailer, right? We're going to supply all these goods. You sell them for us. Or you attach these two parts together in your company and then sell it, knowing that part A and part B are not actually patented individually, but when they're combined, that system is what's patented, but they're actually causing the other party to do that, okay? That's inducement, and it's also called contributory infringement. Those are different ways that party A in this scenario, this question, would be liable. Party B is in some cases still liable, but there's a good defense there that they'll be able to point back at party A. The interesting thing about patent law, though, is that there's no innocence is not an affirmative defense. Unknowing infringement doesn't help you; you're still infringing. But I think they're going to be out of the loop on getting additional damages because you can get additional what's called treble damages if you know about a patent and yet you still infringe. So if you're giving notice either directly by the patent owner or through constructive notice, right? You should have known, you were provided information by a third party and there's evidence of that. Then you knew about the patent and then you still infringed it. The courts don't like that. The federal court wants to make sure that those infringers, those willful infringers, are punished extra. And so there's additional damages for them. Flavio, good to see you. Did I miss my question? Yeah, you might have. Once you re-ask your question, I was very out for the first 15 minutes of the call. Had a very strange audio issue. Had to kind of come back from. So yeah, ask again. I'll get to you. All right. Any other questions as well? I will take those first and foremost. Okay. So I jumped to Avo. I'll jump back to our trademark questions here. I said we had 4, and I got about 5 to 6 more minutes coming up here. Let's do a screen share so I can show you guys some of these questions because it's easier to show them to you versus copying them into the blanks. This first one's out of New York. And once it opens up, it says, if I forget to renew a trademark registration and it gets canceled, do I have to stop using the R symbol? I registered a trademark many years ago. I forgot to renew a trademark registration and it's past its 6 months of extra time. Do I need to stop using the R symbol? Yes. Yeah, it's no longer on the principal register once it's dead. Dead is the actual status of an inactive trademark. And once it's lost its registration status, unfortunately, you do have to remove the symbol. It's kind of difficult because it is quite simple to revive, right? To pay the fee and to revive. Once you get it revived, of course, you can restore that registration symbol. That's the technical answer. All right, let's go to the second question I think I saw on YouTube out of Avon, Ohio. I've recently started a YouTube channel for Bengali song music video. Do I need to trademark it? I use the pen name instead of a legal name. I can affidavit my pen name. Question mark. Thank you. Okay, so they've got a channel. They want to see if they should or could trademark the channel. Sure. I mean, depending on what's going on. If you're the one producing the music, if you're providing a service, maybe even giving your opinions on music types of video, then it is something that is registrable. A trademark is the federal trademark law provides registration for goods and services in the U.S. And if you can demonstrate that it's a distinct mark, right? That your mark is separate from the goods or services that you're selling, right? If you're selling, bottled water, and your company's name is Bottled Water, you're not going to be able to get protection for that because it merely describes what you're selling. But if it's distinctive and not confusingly similar to another company that has already registered their mark or in the same space as you, you can seek registration. And it's a great way to do that. I think YouTube is phenomenal. I mean, we're here broadcasting live on YouTube here. It's a great way to sort of buttress and support your brand and get that out to as many people as possible. So I say go for it and reach out to us if you have any questions. So let me stop sharing here and I take a question here from Justin. And all right, here we go. So if you get a patent in the US and start selling, and a company out of the country makes a product that looks and works the same as yours, that's patented in the US, will they be able to sell it in the States? The answer is no. The answer is no. If you get a patent in the US, you have the ability to exclude, right, to prevent anyone from making, using, selling, or importing your patent to the US, all right? Will they be able to sell in other countries? Yes, maybe, right? If you did not secure international rights, then you will not, okay? You can only enforce your rights in the jurisdictions for which you have been granted. We work with a lot of our inventors to file under the PCT, the Patent Cooperation Treaty, to seek international rights. And what it does is it allows you more time to sort of prove, to make sure this patent is going to be valuable in the US. And then within an 18-month window, you can then file into 100 plus other countries around the world. Almost every country you know of, you've heard of, is a member of that treaty. So it's a very powerful mechanism to reserve the right to have those protections in other jurisdictions. So I hope that helps a lot. But if you only, like I said, to circle back, if you only have rights in the US, you will not be able to prevent anyone from making, using, or selling outside the US. Right? So if you think there's a real market, a potential, someone, a good enough market overseas, you should seriously consider international protection. So thanks for that question, Justin. I want to pop in before our time is up. I know like I said, I really had a bobbled start to our day. So thanks for those that are sticking with. I want to give a link to this book behind me, Bold Ideas, The Inventor's Guide to Patents. This is a book that we're giving away for free. And we do so if you are willing to take the bold move and schedule a screening session. So there's your link to schedule a screening session if maybe you were thinking about getting started, or maybe you know someone that's got an idea, right? Aunt, uncle, brother, sister, a relative. Send a link to them. Send this out to them. We're here every Wednesday at 9 a.m. Pacific and noon on the East Coast. This book here is yours. It's a free PDF download. All the basics of patent law. What's the difference between a provisional and non-provisional? You name it. Trademark, copyright, trade secret. All right, Flavio, your question. You filed a non-provisional utility before the allowance of issue of the swirl fork design patent. So will I get both patents come together? Beautiful, beautiful. Yeah. So what you did is you expanded your portfolio, Mr. Flavio. So it looks like you've got You've got a design patent that's been allowed, means the examiner said, this looks good. This is novel and non-obvious, and we're going to allow it. Meaning all you got to do, Mr. and Mrs. Inventor, is pay the fee, and we're going to issue it. I mean, you'll have the rights. Now, for a design patent, you get 15 years after the date of issuance. The key here, and what you did take advantage of, and which we always encourage our inventors to do, is before that first parent filing gets issued, you want to seriously consider filing a continuation, meaning a child patent, so that you have additional rights that you might be able to go after. Because as soon as that parent issues, you won't be able to file any more children. And that portfolio is stuck at just one patent asset. And I'm talking quickly, but in your case, what you did is you filed a utility, right? So you followed up your design that was allowed, the swirl fork, and you came in with a utility to go seek functional protection, right? Separate from the aesthetics, right? The examiner said, yes, this design, this look and feel is patentable. And you say, okay, well, I want to now go after the functionality of what this fork actually does. And you are now pending with a utility patent application. So you've hopefully got the best of both worlds on the way. You'll be getting a design patent issued soon. And hopefully, if all goes well with the utility, the functional utility patent as well. It's the belt and suspenders. It's the best way to protect a product on the market today. So kudos to you, Flavia. And Justin, glad to hear you booked up. That's awesome. Yeah, welcome to the bold world. And we'll hopefully have you here up to speed shortly. All right, everybody, we're going to wrap up. It's 9:30. Thank you again for tuning in and hanging in with me. Sorry about the technical difficulties. We'll be back next week without those hitches. Have a good day, everybody, and good week. Go big, go bold.